Civil Code of the Philippines, Book 3, Title 4, Succession, Chapter 1, General Provisions, Article 774, Succession is a mode of acquisition by virtue of which the property, rights, and obligations to the extent of the value of the inheritance of a person are transmitted through his death to another or others, either by his will or by operation of law. Article 775. In this title, decedent is the general term applied to the person whose property is transmitted through succession, whether or not he left a will. If he left a will, he also called the testator. Article 776. The inheritance includes all the property, rights, and obligations of a person which are not extinguished by his death. Article 777. The rights to the succession are transmitted from the moment of the death of the decedent. Article 778. Succession may be 1. Testamentary, 2. Legal or intestate, or 3. Mixed. Article 779. Testamentary succession is that which results from the designation of an heir made in a will executed in the form prescribed by law. Article 780. Mixed succession is that affected partly by will and partly by operation of law. Article 781. The inheritance of a person includes not only the property and the transmissible rights and obligations existing at the time of his death, but also those which have accrued thereto since the opening of the succession. Article 782. An heir is a person called to the succession either by the provision of a will or by operation of law. Devices and legatees are person to whom gift of real and personal property are respectively given by virtue of a will. Chapter 2, Testamentary Succession. Section 1, Wills. Subsection 1, Wills in general. Article 783. A will is an act whereby a person is permitted, with the formalities prescribed by law, to control to a certain degree the disposition of his estate, to take effect after his death. Article 784. The making of a will is a strictly personal act. It cannot be left in whose or in part to the discretion of a third person, or accomplished through instrumentality of an agent or attorney. Article 785. The duration or efficacy of the designation of heirs, devices, or legatees, or the determination of the portion which they are to take, when referred to by name, cannot be left to the discretion of a third person. Article 786. The testator may entrust to a third person the distribution of a specific property or sum of money that he may leave in general to specified classes or causes, and also the designation of the person's institution or establishment to which such property or sums of money are to be given or applied. Article 787. The testator may not make a testamentary disposition in such manner that another person has to determine whether or not it is to be operative. Article 788. If a testamentary disposition admits of different interpretation, in case of doubt, that interpretation by which the disposition is to be operative shall be preferred. 789. When there is an imperfect description or when no person or property exactly answers the description, mistakes and omission must be corrected. If the error appears from the context of the will or from extrinsic evidence, excluding the oral declarations of the testator as to his intention, and when an uncertainty arises upon the face of the will as to the application of any of its provisions, the testator's intention is to be ascertained from the words of the will, taking into consideration the circumstances under which it was made, excluding such oral declaration. Article 790. The words of a will are to be taken in their ordinary and grammatical sense, unless a clear intention to use them in another sense can be gathered, and that other can be ascertained. Technical works in a will are to be taken in their technical senses, unless the context clearly indicates a contrary intention, or unless it satisfactorily appears that the will has drawn solely by the testator and that he was unacquainted with such technical sense. Article 791. The words of a will are to receive an interpretation which will give to every expression some effect, rather than one which will render any of the expressions inoperative. And of two modes of interpreting a will that is to be preferred, which will prevent intestacy. Article 792. Invalidity of one of several dispositions contained in a will does not result in the invalidity of other disposition, unless it is to be presumed that the testator would not have such other dispositions if the first invalid disposition had not been made. Article 793. Property acquired after the making of a will shall only pass thereby as if the testator had possessed it at the time of making the will, should it expressly appear by the will that such was his intention. Article 794. Every device or legacy shall convey all the interest which the testator could devise or bequeath in the property disposed of, unless it clearly appears from the will that he intended to convey a less interest. Article 795. The validity of a will as to its forms depends upon the observance of the law in force at the time it is made. Subsection 2. Testamentary capacity and intent. Article 796. All persons who are not expressly prohibited by law may make a will. 797. Persons of either sex under 18 years of age cannot make a will. And Article 798. In order to make a will, it is essential that the testator be of sound mind at the time of its execution. Again, in order to make a will, it is essential that the testator be of sound mind at the time of its execution. Article 799. To be of sound mind, it is not necessary that the testator be in full possession of all his reasoning faculties, or that his mind be wholly unbroken, unimpaired, or unshattered by disease, injury, or other cause. It shall be sufficient if the testator was able at the time of making the will to know the nature of the estate to be disposed of, the proper objects of his bounty, and the character of the testamentary act. Article 800. The law presumes that every person is of sound mind in the absence of proof to the contrary. The burden of proof that the testator was not of sound mind at the time of making his disposition is on the person who possessed the probate of the will. But the testator, 1 month or less before making his will, was publicly known to be insane, the person who maintains the validity of the will must prove that the testator made it during a lucid interval. Article 801, supervening incapacity does not invalidate an effective will, nor it nor is the will of an incapable validated by the supervening of capacity. Article 802. A married woman may make a will without the consent of her husband and without the authority of the court. Article 803. A married woman may dispose by will of all her separate property as well as her share of the conjugal partnership or voluntary community property.